Today's guest is a newbie to us. He is a New York City attorney. His name is Yoni Levoritz. And we are going to be talking about relocations and parenting plans, especially for people dealing with difficult divorces, separations, custody battles, etc. And relocations tend to be very difficult in situations like ours. A lot of times, somebody really wants to get away, and they often don't don't argue the right reasons for why they want to move. So before we even start, Yoni, before you introduce yourself, can you just say what is a relocation?
A relocation is basically a moving away from the non-custodial parent. It could be as little as 20 miles or 10 miles. In fact, there's a case about a short-term move from Brooklyn to Staten Island in New York, which is very short-term in terms of distance. But because of traffic patterns, the court denied the application.
Really?
So, yeah, it's a major issue. So you have to be careful with where you pick and how you position yourself, and how, of course, you show the analysis to the court. And you have to pick some place that's going to have real reasons attached to it: economic benefits, economic deficits, pros and cons for the child, pros and cons for you in terms of economics. So, yeah, it's a tricky situation, but you can get there.
Oh, good.
And you
All
can
right.
fight for it, and you should.
So now can you introduce yourself and say who you are and where you practice?
Sure. My name is Yoni Levoritz. I practice in Manhattan primarily, but also in Brooklyn and the outer boroughs, Westchester, and of course Long Island, Nassau and Suffolk. I only practice family law. It's what I do every day of the week. It's a wonderful and fulfilling job, and I do this with people who have very complicated divorces, not run-of-the-mill, but primarily on the more complex side of things.
Okay, well, that's our audience. So thank you so much for talking to us about it. I know that when we first met, I was saying that people tend to make a mistake in our community of saying, I want to move because I need to get away from my ex. Can you talk about why that's a mistake?
Sure, because one of the main factors in custody is the ability to foster a relationship. And by saying I want to move away from my ex, you're saying, oh, I can't foster a relationship, which makes you, as the appellate division says in some cases, per se, meaning automatically incapable of being the custodial parent. So you want to stay away from that. You want to, when I do these things, I basically try and put myself in a position where I can argue the domestic violence in terms of equitable distribution, because that is a factor. I can argue these things in terms of relocation, in terms of best interest of the child, but I try and keep my boxes separate, and I try not to say things that are going to put us in a position where we're locked in terms of relocation issues.
Yeah, can you talk a little bit about the case that you had where a relocation was denied at the family court level and then you successfully appealed it?
Sure. At the family court level, the person was seeking a relocation to upstate New York, Binghamton. Husband lived in Brooklyn. Boyfriend and girlfriend lived in Brooklyn. Boyfriend did not pay support. Boyfriend was abusive. He was abusive in many ways, not only not paying support, which is very common among abusive relationships, and abusing the power, but it's one of the things that he did. So when it came time to argue before the appellate division, I did not handle the trial court matter. That was handled by a different lawyer. But we did not really argue the domestic violence issues. We did not argue those issues really at all. We focused in on the best interest of the child.
And then I think I remember you talking also about economic opportunity and saying that because the other person wasn't paying, that impacted the situation.
Sure. The fact that they weren't paying support created a situation where Brooklyn, which is very expensive, was simply unfeasible for the client. She couldn't handle the rent. She couldn't handle the payments. So at that point in time, we were able to argue basically an economic defense to the husband's claim or boyfriend's
Yeah.
claim.
Yeah. That's great. Okay, so going backward, even before relocation, we always say that the parenting plan becomes your constitution. That's something that you have to start thinking about if you have children, how things are going to go moving forward, at least until the child is 18 in most places. So you talked about how there's certain things that people should really think about including in a parenting plan, especially with our audience of difficult relationships separating. And one of them was therapy. Can you talk about why it's important to get that in sooner rather than later?
Sure, because what's going to happen is if you don't have an established system with therapy inside the actual parenting agreement or the final stipulation with regard to parenting, you're going to put yourself in a situation where you're not going to be able to get therapy for the child because the other spouse is always going to disagree with you. The other partner is always going to disagree with you. They're going to use this as a power play, okay, which is what abusive relationships are all about. They're about power and control. So when we're talking about the power and control, we have to look at the fact that we have to get certain things in there. Relocation provisions. You want a radius provision. You want a provision regarding therapy. You want a provision regarding who's going to make final decisions in certain areas and try and get as much power for yourself as you possibly can to avoid altercations with the other spouse or boyfriend or girlfriend or wherever it may be.
Yeah, yeah. So in terms of therapy, I thought it was really interesting that you talked to me, and I want you to share now with everyone how the courts don't will are less likely to order therapy for certain aged kids. You said, I think the range that they expect to have therapy ordered, if let's say it's not a parenting plan, is like 6 to 10. Can you talk about why that and why not the other ages as much?
Sure. What happens is after a child becomes in the tweens and in the teens, they vote with their feet. Okay. So what happens is they simply pick up and say, Mom, Dad, I'm not going to therapy anymore. And you've got two choices. You drag them by the hair into the car, which is not a viable option. Okay. And I would highly recommend you don't do that. Okay. Or in the alternative, what you do is you simply try and have as much therapy as possible for yourself to learn how to deal with that particular teenager. Because you're not going to be able to get them into the car to get them to therapy. Which is also why when you have younger children, focus in on therapy. In fact, even before the divorce starts or even before the family court action starts, you should have the child in therapy. That way it becomes a question of changing therapists possibly to someone more neutral that you didn't pick rather than not having therapy in general.
Mm-hmm. And then, but you also had said that a lot of times courts won't order therapy for kids that are really little, like 2 to 4.
Yes.
Talk about why not? Because I think people think, okay, I'm getting a divorce. I have like a baby and I want my really young child in therapy and expect to get that too.
Well, what happens is with really young children, since it's play therapy for the most part, um, a lot of judges don't look too highly upon it. You know, it's just one of those things that you run into circumstances when you're in court. They say the child is too young, or the child is so young, or does the child really need this? Does it have to interfere with parenting time? You know, is there something really necessary? And I would argue that it is really necessary because a child expressing their emotions and learning to express the situations that they've gone through with the other spouse or a boyfriend or girlfriend or whoever it may be, you have to be able to expand upon that. Children need to start learning to express themselves at a young age when they're in such a traumatic situation.
Yeah, yeah. All right. Another thing that we talked about to include in a parenting plan, which a lot of people don't think about, is what's going to happen in terms of education after high school. Now, I just think, oh, college. But you talked about another thing that absolutely should be considered and included in a plan.
Sure, I think there should always be a provision that both parents agree that the child or children are going to go to college, that they're going to go to a trade school, that they're going to pursue a secondary education. No matter what that secondary education may be, they're going to pursue something to make them economically viable in the real world. So you should not just leave it off at high school education. You should always have a provision. You know, the courts in New York won't deal with college until they're 16 or 17 or 15, you know, depending upon the judge and the court and everything else. But it's upper teens, basically. And if you want an order saying that the child should go to college. But any agreement should have the fact that that the intent is that the children will go to a secondary education program.
All right, and then I'm thinking about who's responsible for contributing, because a lot of our clients are throughout the world, and certain, at least in America, certain states don't require that both parents pay for college. And if they don't have something in their parenting plan like I had that said each of the parents agree that had they stayed together, they would support the child's education, that each agree to contribute in some way, that you might end up having to take care of it yourself or have your child shoulder the entire debt, right?
Well, I can't speak to cases outside of New York because I'm only licensed in New
Mhm.
York. But what I can say is the more definitive you are in terms of the provision, in terms of how college is going to be paid for, the better off you're going to be. Even when I deal with 6 and 7 year olds, there are times where I put in a full-blown college provision and say, listen, we're going to do a SUNY cap. At least that way I know the child's going to have a secondary education up to the State University of New York, which is SUNY, okay, and they're going to have at least that amount of money to go to school, okay, plus room, plus board, you know, plus meal plan, which is what I always put in.
Yeah,
So
yeah.
you got to dot your I's and cross your T's in terms of these things, except in the case of New York, since college basically is paid for by the parents in most cases, up until the age of 21 at least. If you have a really superior child who's extremely bright, who may make Ivy League, you may want to rethink that and say, I'll go for the money later on.
Mhm.
That's the only time I would diverge from that. But typically speaking, I want to get a college provision in, unless it's going to be a major fight with the other side, in which case I simply get the intent paragraph in.
That's what I had, and when I went back as a pro se, I managed to get you know, we call it the educational support order, and the
Correct.
division was great. But yeah, okay. What about figuring out how much each person should contribute? Is there a formula for that for college, or how is it decided? Like, let's say we get the clause in there that says we'll each contribute. Like, what has to happen to then decide who contributes what?
Typically, I put in a pro rata
Mhm.
split, which
What is
basically
that?
means in English, okay, that you're going to pay proportionately to your income. So hypothetically speaking, income is $100,000. You'd each have a 50-50 split because you're each making $50,000 in the pot, okay? And then from there, you take it to a 50-50 split. In the alternative, what you could do is you could say, listen, you know, based upon the 529 accounts or based upon, you know, uniform gift to minors accounts, we're going to use those funds first and then it will be split equally,
Mhm.
which I really don't like because there are many times, especially with people who did not work outside the household and mothers who stayed home, that suffer economically as a result of the divorce. Okay. So you want to put yourself in a position where it's basically pro rata. That is the ultimate goal.
Okay, so speaking of that, one of the really common issues we see in our community is that during a divorce, um, when everyone's arguing about money, that the moneyed spouse suddenly doesn't work or says they had a really bad year, and they can't pay child support as much. And you said that income isn't necessarily based on what you're making at that moment. Can you talk a little bit about that? Because I think that's common, not just in New York State.
Sure. Based upon the case law in New York, okay, child support is based upon, and spousal support slash maintenance slash alimony, they're based upon your ability to generate income, not, not necessarily your current economic circumstances.
Right. So
So,
go ahead.
sorry, go ahead.
No, I was going to say, what is a vocational expert?
Vocational experts. Vocational experts are people who value your ability to work, okay, that value your ability to generate income in the outside world. We use them for unemployed people on a regular basis. What happens is they say, or what we call instant poverty syndrome, which is another way of saying, I'm getting divorced, therefore I'm going broke.
That's a good one.
Okay. So what you have is a situation where, um, you know, uh, how do I explain this? Basically, you want to go ahead and you want to hire the outside expert to say, listen, they may only be making $85,000 a year, but they're constantly having the ability to use their education to get themselves up to $185,000 a year. They're choosing not to make that income. It's based upon capability and ability rather than their current economic circumstances.
Yeah. We just got a comment about, it's someone over in the UK. My ex claims that he doesn't work anymore and pays only £30 for both children. So often we have people who say, I'm not working right now. And we were just talking to somebody yesterday who was saying their ex hasn't worked in a year and a half, but is taking trips to Australia and other beautiful parts of the world, but saying they have no money.
These things have got to be presented to the court, and you got to do it in a nice way. You got to do it with pictures. You got to do it with your Instagram accounts. You got to do it with your Facebook accounts. You've got to nail these things down and say to the court, listen, my child should be entitled to some of the lifestyle that their father has.
Mm-hmm.
And basically paint the picture for the court. You got to spoon feed them to a certain extent.
Yeah.
Because the evidence is necessary for them to have their hat to hang on the proverbial hook and to say, listen, sir, you're not going to get away with this in my court.
I love it. And not just because it's father or mother. It's just that, you know, when someone is saying they're poor, but they're living this wonderful life, and especially posting about it on social media, we have to, as the parties bringing them to court, we have to help gather that evidence. And that is really helpful.
Got to help out. It's a team effort. Every divorce, every family court action is a team effort between you and your lawyer to put these things together.
Yeah. One of the things we also talked about was communication. And that's something that Chris and I, my partner and I, are working on with our clients more than anything else. And often people are terrified to communicate in writing with their ex because they say they get this wall of fury, this really just angry text. And you said this beautiful line that we've been repeating since we first spoke, their anger is your gold. Can you say why?
That is correct. You know, basically, the more anger you get out of them, the more venomous they are, the more that you should be able to argue that they do not have the ability to foster a relationship, and therefore their access should be curtailed. They should not be able to go ahead and express themselves or have such a venomous attitude, okay, in general around the children. And if that requires supervised visitation, then so be it.
All right. I was going to say, how hard is that to prove in court? Just so people don't think
text
that's
messages.
Super easy. Yes.
Those text messages are gold.
Okay. Another thing that that we talked about is how when the child is often at a difficult parent's house and they're having FaceTimes with, let's say, our client, there's no privacy. And you said that I thought, well, there's nothing you can really do about it because the child is over there and you can't control it. But you said there's actually something that you can put in a parenting plan about that. Can you talk about that? Because that was news to me.
Sure. You always want to have in your parenting plan, okay, or your final stipulation with regard to the children, you want to have a statement or a paragraph that says that the child shall always be in private, okay, and not exposed to the other parent during phone calls. You want to give the child an opportunity to speak to the other parent unhindered by the looks, the grimaces, the faces, the idea of presents, of course, you know, that comes up. Oh, don't talk to them. You know, we'll give you a present if you're really nice and don't talk to them. Okay. So you want to have as much of a provision as possible, which prevents those things from happening. And if people don't abide by them, take them back to court, file a violation, file a contempt motion.
Okay. So we talked about that too, because I said, how is that going to be enforceable? Because we know that that's really hard to prove, and that you said a lot of times you'll go in and you'll have your evidence, and the other person will get a slap on the wrist 1, 2, 3 times. How can someone afford to go back and hire an attorney to do something like that?
Well, in New York, we have family court. So, you just go into family court, you file a violation petition. It takes a few hours, there's no doubt about it, but you can do it on your own. Okay, but you got to have the evidence for it. And there's no reason why you can't do it on your own. You don't need a lawyer for everything you do.
Yeah. So I love that you're showing your integrity by encouraging people to do certain things on their own, because that is so helpful. And I think I told you
in every case, clients have to help out.
Yeah.
They got to pull their weight too, just like the lawyer has to pull their weight and advise them as to what they can and can't do on their own, and help out with these things.
Yeah. All right, we're getting a question. What about when they put their girlfriend or others on the phone to provoke the other parent? Or when the girlfriend posts the kids on social media, but the other side, the father doesn't. So not the actual other parent, but that parent's new partner gets involved. How often do you see that?
We see it quite often. It's a problem. That's why, again, parenting plans have to be very detailed. They have to be very specific, and stipulations have to be specific. And that girlfriends, or if you don't want social media, have it in your agreement. Unfortunately, most judges won't stop one parent from posting on social media while the other parent doesn't do it. They're not going to order that automatically. So what you have to do is you have to put yourself in a situation where you're going to have that in the parenting plan itself. In terms of having, excuse me?
Sorry, and what would be the consequences? Like, I always think about kind of things to put in the parenting plan, but might not necessarily be easy to enforce. So if you say in the parenting plan, no posting our child on social media, and they do it anyway, like, what are the consequences? Like, what could you actually put that's realistic to happen if they do it, when they do it?
It's a great question. Typically speaking, I like to punish people with counsel fee awards. Because if they have to pay your lawyer's counsel fees, and that's why we have a section dealing with that particular issue, okay? If you violate the agreement in any way, and we have a court order that is in our favor, okay, then at that point in time, you're going to have to pay my counsel fees.
Wow.
Or whichever lawyer is working for you. So if they go into court and they lose $5,000, $3,500, $10,000, whatever it may be, depending upon the violations that have transpired, you're going to put a dent in their pockets, and they're going to feel it, and they're going to be angry about it. And hopefully they won't repeat the behavior.
Yeah. I mean, do you think that applies also to the right of first refusal? And before you answer that, can you explain what the right of first refusal is? Because that comes up all the time too.
Sure. The right of first refusal is basically when a person is not going to be available for visitation or for access, and therefore they should give it back to the other party. Okay. So hypothetically speaking, you have a situation where the husband is supposed to see the children on Tuesdays. Tuesday, he can't see them. Mother says, I have a right of first refusal. Therefore, I'm going to take the kids. You're not going to leave them with your girlfriend. You're not going to leave them with your mother. You're not going to leave them with someone else because you can't see them. Therefore, I get to have the time.
Okay. So what happens when you have that clause, the right of first refusal in your parenting plan, and someone consistently violates? Because I'm not talking about just once.
Consistently violating it, again, we're going to shoot for a few things. One, contempt, okay, for violating the court order. Two, we're going to shoot for a modification of custody and visitation time, saying that they can't take the time, therefore they shouldn't have it. Three, we're going to shoot for counsel fees.
All right. Okay. What about, this happens all the time. You have a parenting plan and someone starts blocking visitation. At what point do you say, ooh, it's time for me to go back to court?
Immediately.
Really? Okay, why is that?
Block visitation one time, you go right back to court, because no matter what you do at that point in time, if you're showing weakness, they're going to take advantage of it. They're going to walk all over you like a rug.
Yeah.
It's going to be absolutely horrible for you. You can't be seen as the weak party.
Yeah, well, that's interesting because some other lawyers in different parts of the world will say wait, but I find that our New Yorkers and Connecticut attorneys are like, go back right away. So it's
Yes.
interesting. Yeah. All right. What about so another thing that came up that I thought your response was interesting was regarding parenting plans. Some people think that it's important to put in, this is gruesome, but if a child dies, what are your thoughts on that?
I think it's morbid. I wouldn't do it. I wouldn't
Yeah.
address the issue. I've never addressed the issue. I've had cases where children have passed away
Hmm.
in the middle of litigation, but I've never addressed it in a parenting plan. I've never addressed it in a stipulation of settlement.
Yeah. Because it's just too many other levels of high emotion going on that why introduce another thing?
That is correct. You don't need it.
Right.
It's
Okay.
not saying that's necessary. In New York, if one parent dies, the child is going to go to the other parent unless they're responsible for the death of the other parent.
No, no, I'm talking about if the child
If the
dies.
child dies, then you're in a situation where unfortunately you don't want to go ahead and start airing that grievance, except in the case there's a life insurance policy. But I wouldn't even want to deal with that. I would deal with it as a change in circumstances for a modification later on in time.
Yeah, if necessary. Okay, somebody asked, what is considered blocking visitation? And I'll say in New York.
Okay. In New York, blocking visitation means preventing it from happening in general. Okay, meaning that you're not going to provide the child for a particular um, visitation session or a visitation period. Or in the alternative, it could mean that you're simply bad mouthing the idea of visitation and therefore basically committing parental alienation.
Okay. What about this is like a murky one. If the child is sick at one parent's house and it's the other parent's parenting time, the other parent wants to see the kid and the kid is capable of getting out of bed. Does the parent who is housing the sick child have to give that parent their parenting time?
I would say yes.
Mhm.
I would say yes, because otherwise you're going to be seen as committing parental alienation and you're going to get a slew of letters and a slew of motions and everything's going to come tumbling down on you for, saying that the child was too sick to have visitation. And why is the other parent not capable of taking care of a sick child? Okay, so you're going to put yourself in a very poor situation. You're going to make yourself look bad in front of the court.
Right.
If it's
I'm really glad you're saying that because I don't think people understand because they're thinking, well, why shouldn't my kid be able to just stay home and stay in bed where they're comfortable? But if the other parent's asking for it, I think they should have the opportunity to show that they're also capable of taking care of a sick child, and you're not the authority on taking care of sick children. So it hurts to hear it, but it's important to know that because we don't want you to get in trouble with the court.
definitely do not want to get in trouble with the court.
Yeah,
You don't want to make the court angry with you.
yeah. All right, another question. My ex doesn't want 50-50 anymore. He only wants contact twice a month. I have family court next week, so I don't have anything to argue against, right? Should I just keep my statement simple?
I wouldn't make any statement at all. I would just agree. This is what he wants. God bless him. I would just keep my mouth shut.
All right.
If the judge asks any questions, I would just say, yes, I agree. If this is what he wants, so absolutely.
Okay.
The
All right.
golden opportunity.
Right, right. Okay, so we talked about insurance before, life insurance, and something that comes up a lot is health insurance. So say you have a parenting plan and one parent's supposed to cover health insurance, and then that parent loses their job in the middle of a divorce. Like, how should we handle this in terms of moving forward, whether it's in the parenting plan already or not, when the health insurance changes? Because that's a big deal.
It is a big deal. And health insurance is extremely expensive.
Mm-hmm.
Okay. It's a very, very expensive proposition. So, in the event that you're in the middle of the divorce, the person who had the insurance has the obligation to maintain the insurance. Now, if it was lost through no fault of his or her own doing, then at that point in time, I would make a motion to the court saying that it should be divided on a pro rata basis based upon the last incomes available.
Okay.
That's
Great.
what I would do.
All right. So I'm thinking, like, is there anything else you would advise people, like, to make sure they include in a parenting plan or think about regarding relocations that I haven't already thought of?
Again, I would just make sure I get that radius clause in there.
Okay.
That radius clause is a golden clause to have, because most judges, even though it's not legally binding, will go ahead and abide by it. They'll say, this is what you agreed to. You know, we don't want to end up in a situation like they did in that 20-mile move from Brooklyn to Staten Island and say, oh, well, traffic patterns don't work out for me.
Yeah. Yeah. Wow.
Okay.
All right,
You
Yoni,
also
thank you
want to
so much.
move as soon as
Okay.
possible.
Oh,
Please
okay.
take that into account. People should take that into account. If you're granted the ability to relocate, move immediately. Don't wait.
All
You know,
right.
get out of there. Go. You're granted something, do it.
Okay. Oh, I was just about to say, how can people find you? But now we have a big question, a huge question. How do you prove parental alienation?
Well, it's very difficult to
Yeah.
prove. Okay. It's not an actual psychiatric or psychological diagnosis. So that makes it even harder to prove because there are no set criteria for it. But children, okay, tend to be alienated, and you can gauge their level of alienation based upon how close they are with certain parents. I'm not going to go through the psychological jargon of it, but basically what happens is children take a side. And if that side is extreme, okay, the child is considered alienated, basically. So if a child at the age of 10 has no reason not to see their mother or not to see their father, and there's no basis for it, you say at that point in time, you need reconciliation therapy, basically, or some other form of therapy to help reunite the parent and the child and possibly take the child away from the other parent, okay, in extreme cases, to try and teach the child that the other parent should not be distanced or alienated.
Yeah, I mean, this is a huge topic. This is actually what we're writing our current book on, as well as a huge online course. But it is like, it's tricky, it's long, it's involved, and I think it's too much to answer here. Let me see. How about this? Another question: how to prove that discussing litigation with the child is consistently happening? The consequences could be asked from court besides, or what consequences could be asked from the court besides supervision. So we know that kids should be shielded from conflict as much as possible. And we see this all the time. And thanks for this great question. One parent keeps drawing them into court matters and the kid is getting really worried. How can you prove that this is happening?
It is very difficult to prove.
Mm-hmm.
However, what you have is a situation where you can actually record the conversations with the child and show that they're doing these things, and then try and address it with the lawyer for the children. Because typically speaking, there's an attorney appointed for the child in these situations.
Mm-hmm.
And that attorney for the child may be useless, may be useful, hard to say. But if they are useful, you'll be able to go ahead and explain to them, listen, they're just being dragged into this litigation on a regular basis, and it's not healthy for them. It's not good for them. And if they're useful, they'll go ahead to the court and explain, listen, my client's being dragged into this litigation, and we need an order that prevents this from happening. So that would make them susceptible to contempt.
Mm-hmm.
That would make them susceptible to economic sanctions in terms of having to enforce it, because you have to move for counsel fees to enforce it, and also supervised visitation, which would be the worst case scenario for the child.
Wow. Yeah, excellent. All right. So Yoni, I was about to say, can you tell people how to find you?
Sure. They can find me, at www.levoritzlaw.com. That's LEVORITZLAW.com. Or, you can just Google my name, Yoni Levoritz, LEVORITZ, and I will come right up.
Yeah. Well, thank you so much. This has been amazingly helpful. I'm sure a lot of people are very excited and have taken notes.
Well, I'm glad to help in any way. I know everybody's going through a very difficult situation, And if I can help them in any way, I'd be very happy to.
Yeah, you already have. And thank you so much, Yoni. Let's stay in touch.
Absolutely. You got it. Thank you. Good luck with the book.
Thank you.
I hope to see a copy.
Oh, you will. Okay.
Thank you.
Bye.
Bye-bye.